these people for doing the right thing.
It's unfortunate that Vietnam is, it's not part of the ICC, and if you guys can get them to be part of it, hands up for you guys. It's a two-part question. Human trafficking is a $7 billion business in the world today, and first of all, the first question is, of the three crimes, genocide, crime against humanity. Now, is human trafficking considered a crime against humanity? And if it's so, has the ICC done anything about it, or do they have plans to prosecute the people around the world, not just in Vietnam, about the human trafficking issue?
You can do this. Crimes against humanity includes the crime of enforced prostitution. It includes the crime against humanity of sexual slavery. Similarly, there are war crimes, the war crime of sexual slavery and the war crime of enforced prostitution. Typically, for the human trafficking, it's those types of situations. And so both of those, if committed on a widespread basis or as part of a policy or procedure, would be considered crimes within the jurisdiction of the court.
Yeah, that's sort of the good news, the cheery view, perhaps. The bad news is, right, to be a war crime, you have to have either an international armed conflict or a domestic armed conflict on a significant scale. So the things that you're talking about probably aren't going to fit into the definition of a war crime. On the definition of a crime against humanity, as you said, the key criteria there is that whatever the conduct is, and it lists, 20 or 30 things that can be a crime against humanity. One of them, a couple of them you just mentioned, include what's the exact terminology, but the idea of enforced prostitution, for example. The problem is it has to be carried out as part of a widespread plan of attack against the civilian population. Okay. And so in the sort of historical development of this crime, what the authors of the international treaties had in mind is probably not the sort of situation that you're describing, right? But it's certainly conceivable that judges in the future could interpret that language to mean that, right? The threshold problem that some, smart prosecuting attorney will have to be making to persuade the judges is that the networks that you're talking about, the $7 billion industry, is in effect part of a widespread systematic plan to attack civilians. That would be the threshold.
Let me add to that I think you may have noted too that during the negotiation in '98 there was effort by NGO to include the language cover human trafficking. But unfortunately, one of the like common international politics, one of the compromise that we have to make is that how you handle and balance all the different interests. There were efforts to include drug trafficking as one of the major crimes because all the South American countries, that's what they want. They want drug trafficking that part of the ICC. So there had to be a lot of compromise that were made, and unfortunately, the language to cover not on NGO.
But, like I said, I think it's broad enough that it's possible that somebody can make a case like that if resources exist today. The other possibility, which you're sort of alluding here to, is that the statute can be amended, right? And it's conceivable that additional crimes could be added, particularly in this review conference in 2009, if there's enough political support in the world to expand the list of crimes. But so far, states are already giving a lot of authority to the Supreme Court, and so they want to.
Mr. Butler, you stated that the Bush administration's position for not joining the ICC was that it might compromise our sovereignty.
That's one of the reasons.
What are the other reasons what are their official positions?
Well, let's see. I have someplace in here.
Well, what we're looking for, one of the objections was that it was not compatible with the United States Constitution, that an American citizen had trial by jury, had a sentence we have a different legal system than what have European countries. So one of the objections that the administration raised is that basically we may have to amend our constitution to be able to comply with some of the procedure that were instituted in the ICC. And I think France actually amended the constitution so that it can join the ICC.
Okay, I have the quote here. When the Bush administration withdrew the signature to the treaty on May 6, 2002, Mark Grossman, the Undersecretary for Political Affairs, said, "We believe the ICC undermines the role of the United Nations Security Council in maintaining international peace and security. We believe in checks and balances. The Rome Statute creates a prosecutorial system that is an unchecked power. We believe that in order to be bound by a treaty, a state must be a party to that treaty. The ICC asserts jurisdiction over citizens of states that have not ratified the treaty. This threatens U.S. sovereignty. We believe the ICC is built on a flawed foundation. These flaws leave it open to exploitation and politically motivated prosecutions." Those were the reasons that are given, and those, I think, are what's been repeated by Bush, that he believes that it's not a good system, that he believes there aren't checks and balances, and he believes that it violates international law to hold individuals who are not nationals of states party to the treaty responsible. But like I said in my talk, the only way that can happen is if it happens on the territory of the state party or by Security Council referral. This doesn't undermine the Security Council's authority for peace and security. In fact, there's a specific provision that allows deferrals of prosecution if the Security Council wants it. There are checks and balances for the prosecutor, and this isn't something that Mike mentioned. He mentioned that the prosecutor can initiate a case on his or her own initiative. However, once the prosecutor decides he or she wants to go forward with the investigation, they need to seek approval from a 3-judge panel of the court to proceed. There are checks and balances, and in fact, if someone believes either the judges or the prosecutors are acting in a politically motivated manner, they can be removed from office on a vote from the Assembly of State Parties. So there are checks and balances. This doesn't threaten U.S. Sovereignty. It's not a violation of treaty law, and this doesn't threaten the Security Council's role in peace and security. Those are the reasons that the administration has given. I disagree with that.
There's also been a lot of talk in the Pentagon about the possibility of a politically motivated trial against the United States, because the United States sounds a lot of troops around the world. Frankly, I don't think there's a lot of merit to that. I mean, the dumbest thing that these judges and prosecutors could do would be to go off on some political crusade that would, in effect, destroy the legitimacy of the ICC, right? I mean, in other words, to prosecute something on trucked up charges that didn't really exist, just to target the United States, to try to humiliate the United States, right? And so I don't see any incentive or reason, for the court to actually do that. These constitutional issues are interesting also that you raised, but I don't know if you have time.
But anyway.
Well, wait. I want to talk about briefly the constitutional issues. The International Criminal Court Treaty gives greater procedural protections to the accused than the U.S. Constitution. Greater procedural protections to the accused than the U.S. Constitution. The one thing that the ICC doesn't have that the Constitution guarantees most U.S. citizens is there is no right to a jury trial. Instead, you're tried by a 3-judge panel. Now, in the United States, I'm a lawyer. I love the jury system because sometimes you can get something over on the jurors. And I think you've seen that happen a lot. You've seen a lot of criminal prosecutions being overturned based on DNA evidence, showing that a jury system, you can fool the jurors. I don't think it's such a bad thing that you don't have a jury system. But other than that, we have greater procedural protections. Second, the U.S. military, for military charges, is typically not permitted constitutionally to have a jury trial. Statutorily, there is a right to a jury trial. It does not violate the U.S. Constitution to try someone in the military without giving them a jury trial. Most of the things that are alleged here are things that you would be trying someone in the military for. Crimes against humanity committed on a widespread scale based on an organizational policy, or war crimes or genocide. Typically, that's going to be the military. So there is no violation of the U.S. Constitution by the International Criminal Court.